Article 11. Justifying circumstances. Number 1. Anyone who acts on defense of his person or rights, provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Number 2. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity in the same degrees, and those consanguinity within the fourth civil degree, provided that the first and second requisite prescribed in the next preceding circumstance are present, and the further requisite in the case the revocation was given by the person attacked, that the one making defense had no part therein. Number 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisite mentioned in the first circumstance of the article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Number 4. Any person who, in order to avoid an evil or injury, does not act which causes damage to other, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that not that than that than to avoid it. Third, that there be no other practical and less harmful means of preventing it. Number 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Article 12. Circumstances which exempt from criminal liability. Number 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, the court shall order his confinement in one of the hospital or asylums established for persons those affected, which he shall not be permitted to live without first obtaining the permission of the same court. Number 2. A person under 9 years of age. A person under 9 years of age. Number 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provision of Art 80 of this code. When such minor is adjudged to be criminally irresponsible, the court in the inconformable conformably with the provision of this and the preceding paragraph shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of irresistible force. Number 6. Any person who acts under the impulse of an uncontrolled. Article 13. Mitigating circumstances. Number 1. Those mentioned in the preceding chapter when all the requisite necessary to justify or to exempt from criminal liability in the respective cases are not attended. Number 2. That the offender is under 18 years of age or over 70 years in the case of the minor, he shall be proceeded against in accordance with the provision of Article 80. Number 3. That the offender had no intention to commit so grave a wrong as that committed. Number 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Number 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, or relatives by affinity within the same degrees. Number 6. That of having act upon an impulse so powerful as naturally to have produced passion or of vocation. Number 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecutor. Number 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect which those restrict his means of action, defense, or communication with his fellow beings. Number 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of the consciousness of his act. Number 10. And finally, any other circumstances of a similar nature and analogous to those above mentioned. Article 14. Aggravating circumstances. Number 1. That advantage be taken by the offender of his public position. Number 2, that the crime be committed in contempt or with insult to the public authorities. Number 3, that the act be committed with insult or in disregard of the respect due the offended party on account of his rank, age, or sex, or that is be committed in the dwelling of the offended party if the latter has not given provocation. Number 4, that the act be committed with abuse of confidence or abuse ungratefulness. Number 5, that the crime be committed in the palace of the chef, executive, or in his presence, or where public authorities are engaged in the discharge of their duties or in a place dedicated to religious worship. Number 6, that the crime be committed in the night time, or in an uninhabit or or an in or an uninhabited place, or by a band, whenever such circumstances may facilitate the commission of the offense. Whenever more than three armed malefac- malefactors shall have act together in the commission of an offense, it shall be deemed to have been committed by a band. Number 7, that the crime be committed on the occasion of an naufragation, shipwreck, earthquake, epidemic, or other calamity or misfortune. Number 8, that the crime be committed with the aid of armed men or person who ensure or afford impunity. Number 9, that the accused is a recidivist. A recidivist is one who at the time of his trial for one crime shall have been previously convicted by final judgment of another. Article 15. Their concept alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effect of the crime and the other conditions attending its commission. They are the relationship in, into intoxic, intoxic, intoxication and the degree of instruction and education of the offender. The alternative circumstance of relationship shall be taken into consideration when the offended party in the spouse, ascendants, descendant, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. The intoxication of the offender shall be taken into consideration as a mitigating circumstances when the offender has committed a felony in the state of intoxication if the same is not be if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstances.